No.
Okay, welcome to the first series of Ask the Attorneys. We plan to do this many times throughout the year, and we really encourage you to go to our Facebook page, which is the Owner Finance Network on Facebook, and post your questions, because we will answer them in these series. So, of course, I have the attorney here with the shiny new boots. Show us those boots, Scott. Okay, I'm not picking on you. All right, are you ready for the questions? Do you have anything you'd like to say?
No, let's just jump right into it.
We're jumping in because we have about 30 questions we're going to ask today. What happens to any lien if the original seller gets them after they close, such as an IRS lien? How does that affect the new buyer that you just wrapped?
So that's really a pretty easy question, and what you should ask yourself is who owns the property? So for instance, if an investor buys a home from a seller, maybe that seller is in distress or has issues, and sometime after they have bought the home and their deed has been recorded, a lien is filed against that seller, it will not affix to the property because who owns it? The investor does, not the seller. Same way with a wraparound mortgage. If an investor sells a home to a home buyer,
right,
and now the home buyer is in deed record title, if the investor gets a lien against them, or if the prior seller gets a lien against them, it will not attach to the property because they are no longer the owner. Okay. Pretty straightforward.
Easy enough. Okay, how do you decide when to get title insurance and when should it be a lender's policy? And that question is on the acquisition and the sales side.
Okay, so when a home is being bought, every purchaser, whether it's an investor or homeowner, has the option to choose to get title insurance or not. I always try to teach the investor community that 98% of the homes that we purchased are homestead properties. And at least here in Texas, only 3 types of liens can attach: purchase money mortgage, tax lien, that's IRS or property tax, or a properly executed mechanics lien contract. It can also be a constitutional mechanics lien contract. Nothing else by law can attach to a homestead property. Now, if it's non-homestead, meaning the individual seller does not live there, different story. All those do attach in that instance. Okay. But most homes we buy are homesteaded in some format. However, here in Texas, judgment liens and child support liens, although they don't attach, title insurance companies want those removed in order to issue title insurance, and that becomes a business decision. Okay. So when we're looking at buying a home, knowing these facts and some basic lien issues, if we know there's an existing mortgage on the property, we're buying it, do we need title insurance? You know, oftentimes we as investors, what's our risk? In other words, Susan, are we putting up $5,000, $10,000, $20,000, $50,000? But we're not putting up the entire amount of the purchase price. Yeah. There's already an existing mortgage that has a title policy in place.
Okay.
So we have to ask ourselves as an investor, do we want title insurance for that smaller amount of risk we're getting? Then, knowing lien issues in what we're buying and how it greatly diminishes what we're looking for, that helps you make that final decision, okay?
Okay.
But the purchaser of the property should be the one to make the decision, no one else. As a closing attorney, I do not dictate title insurance. I let the purchaser make that call all the way through. Now, on the flip side, when we're selling a home to a home buyer, again, we do not want to tell a home buyer what to do or what not to do. We want them to make an informed decision. Now, for instance, in our disclosure packages that we provide to the investment community and the home selling community out there in these situations, it gives the buyer the option to choose what type of title evidence they want. And think about it, there's several types. You can get a title search, name search, which that and an abstract is the same thing as a title commitment.
Okay.
It's just not title insurance. In other words, it's not backed by insurance. There's not a guarantee behind it in that instance. But I don't want to dictate my home buyer title insurance. But what I have found is that As the lender, I'm not requiring title insurance. I'm not asking that home buyer to give me a mortgagee's title policy. So in that instance, the role flip-flops back to the buyer to make the decision, do they want title insurance or not?
Okay.
Now, if you're dealing with a realtor in a transaction, they are so used to every deal having title insurance, it seems like even on a seller finance, they want to ask for it. Well, when I explain to them that I'm not getting 100% of my down payment of my sales price, I'm only getting 10% or 15% in a down payment,
Mm-hmm.
I'm not willing to pay for the buyer's title insurance in that instance.
Okay.
So I'm never telling the buyer no, I'm just saying I'm not willing to pay for it. So it's a different scenario.
Okay. So they can buy it if they want it.
They can buy it if they want it, but keep in mind, in Texas at least, where the underlying debt, if there is one, is an FHA, VA, or home equity loan, most oftentimes title insurance will not be available in that situation. If the underlying debt is conventional, maybe it's small commercial bank or private capital, in most instances it would be available.
Okay. And what about the lender's policy? Where does that fit in?
Well, normally you don't need a lender's policy. If we're buying a house from a home seller as an investor, we don't need a lender's policy unless there's maybe a second lien holder involved and they want it.
Okay.
In that case, that would be pretty easy to get, I think. But when selling a property to a home buyer, let's say we're using a wraparound mortgage again, do I want to have a lender's policy with my buyer? Now, the only time I can think I would want that per se is if my intent is to sell that mortgage down the road.
Mm-hmm.
But understand, I can always buy that lender's policy in the future.
Oh, okay.
So do I want to spend the money today or in 1 or 2 years from now? Again, that's an individual choice to make.
Okay. And you would buy it down the road if you were wanting to sell the note? Is that what you're saying?
You can.
Okay. Okay. Next question is, what is exactly is the RMLO supposed to do, and what are they responsible for?
Great question, and I get that asked me probably daily.
Mm-hmm.
So an RMLO, of course, is the residential mortgage loan originator, and in the seller finance world, they are the loan processor. They work with a home buyer, someone's going to be their homestead, in gathering their financial information.
Mm-hmm.
I like to use an RMLO in every transaction, whether we may or may not be exempt. And again, under Dodd-Frank, I believe that you are able to do 5 transactions in a 12-month period and be exempt. Under the SAFE Act here in Texas, there's a 5 property de minimis rule also. Other states, though, don't have that. It's obligated under every transaction to incorporate the RMLO. But then under RESPA, which is the Real Estate Settlement Procedures Act, there's only a 3 property de minimis rule. So that means if you do 3 or less deals in a 12-month period of time, you should be using an RMLO here in Texas. Now, regardless of that, we should use one every single time. It's just a smart fail-safe. Now, the RMLO has one job and one job only, and that is to gather the financial information, provide the 36 or so RESPA disclosures to the buyer, and then give to the seller, who is the lender, most likely in most cases the investor, the application package. That is the seller, who is also the lender in the owner finance transaction, who is also the underwriter's obligation to approve their buyer. The RMLO has no licensing and no authority to approve the buyer.
And so many people think they do.
Well, they want the RMLO to take more responsibility, and that's not their role. We have to understand that if we are the seller, if we are the investor selling a home to a home buyer, it is our responsibility as the lender to underwrite and approve the buyer only. But we're going to use the information provided to us by the RMLO.
Okay. Okay, the next question. How do you decide on the terms of a sub-2 wrap sale?
That sounds confusing. I think the question they meant to ask is, how do we determine, well, let's bifurcate that.
Okay.
If we're going to buy a house and we're buying it subject to, how do we decide on the terms of buying that? Well, first off, are we going to buy it subject to the existing debt, leaving that debt in place, or are we going to do a wraparound mortgage?
Okay.
The next question to ask is, does the seller want cash, or do they want too much cash, where maybe I need to give them some cash and maybe a second lien on the property?
Okay.
if we're going to buy that home subject to, it's just asking questions what that seller really wants. Do they need walkaway cash? Is there real legitimate equity in the transaction that they want? Every deal is going to be a little bit different. And then I like to offer my sellers, I like to start somewhere around a 6% interest rate, much higher than they can get in a bank or in the stock market right now in mutual funds. I can always work that up a little bit higher if I need to. Now, the real question is I want to sell my home to a back-end home buyer. How do I put that deal together and structure it, right?
Right.
Well, first off, I like to take the market value, let's assume for conversation here, it's $100,000. I like to do about a 10% markup. Sometimes I might do 5, sometimes I might do 15% based on the price range. Let's say in this case it's a 10% markup, so I'm going to sell it for 110. Right now, in the Texas marketplace, on a lower end property like that, I can usually incorporate a 10% interest rate. That's just a learning thing. But what I'm going to look at is when I run a 10% rate, let's say I get a 10% down payment, or I get, in this case, let's call it $10,000. I carry back a $100,000 loan, and I'm going to carry a 10% interest rate on it. I'm going to look at what my principal, interest, tax, and insurance is over a 30-year period. How does that compare to the rental marketplace? And I hate to use the word, how does it feel for that property and for that location? But sometimes you can get that a little bit. Sometimes the price just seems too high. Sometimes it seems too low also. And so that's just knowing your neighborhoods that you're doing business in. From there, I might look at it on a 20-year note basis. Now, the smaller your home, you can have a lower amortization, 30, 20, 15, maybe 10. As your price of your home goes up, 200,000 price range, 300,000, if you have a 15-year mortgage on that, the payment's going to be very high for most people, and you can't do that. Right. But also, as your sales price increases, your interest rate has to decrease, because interest rates are logarithmic in nature. And can you imagine a 10% interest rate on a $300,000 loan? I mean, that would choke a mule, as we say. And so you have to bring that interest rate down. But think about this also. If I'm charging a 10% rate on $100,000 versus charging maybe a 8% rate on $300,000, I'm getting 8% on 3 times the amount of my loan, which means my true net profit is going to be higher in today. And so you have to make every transaction reasonable. You've got to look at what the principal, interest, tax, and insurance payment is. You've got to compare that to the rental marketplace, and you can be about 110% of the rental marketplace and still sell your home. Remember, that home buyer is going to get the right to write off their property taxes and their interest on that mortgage, so they get the benefit. And they own the home, they don't just rent it. So there's no one direct answer, but normally it's going to be tied to running your numbers, comparing it to the rental marketplace. Look at other sales in the area, and what is the current mortgage marketplace doing? Is an A-plus mortgage 4%, 5%, 6%? They are going to start going back up again. And then you make that best decision you can. And then once you're marketing your home, you listen to the marketplace. It will tell you if you're in tune in pricing in the correct way.
Okay, this is an interesting question. On a sub 2, what is the exit strategy when the seller wants to be off the original note after 2 or 3 years? So the example is that the seller owes $50,000 on his mortgage and agrees to a $75,000 wraparound for part of his equity, but he wants his name off the $50,000 mortgage in 3 years.
Well, I get the question, but again, it's asked wrong, because in that instance, the seller wants to have their underlying debt paid off, right? So that means after 5 years, you're going to find a way to pay it off, period. If you're buying the home subject to the debt, you cannot change the terms of the underlying debt. Only the original seller and the mortgage company can do that. So you're not going to create a balloon payment in that case. So what you have to do is you have to create a wraparound mortgage. With a wraparound mortgage, of course, it can have the identical terms and conditions of that underlying debt, but now you can build in that balloon feature into the transaction, that 5 years. But it's not going to be just pay off the 50 and keep 25, unless the investor has a lot of cash they want to put into it. So most likely in those cases, that investor is going to have the ability to either cash out that investor in some format through institutional funding, private capital, through some other scenario, or maybe if they selling the rental property if it's rental, or if it's an owner finance transaction, selling the note but paying off the lender in full.
Okay.